And on this morning's Ag Issues program, a pleasure as always to bring on to the program Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. I'm doing fine. Other than a busted grain deal and shortage of diesel and a possible rail worker strike in ag, personally, I'm doing okay.
Yeah, what else could be happening right now? Hey, you got me a very good topic of discussion today, and tax preparers out there, they're getting faced with farm and ranch clients that are seeing ads again in farm magazines, and I think we've seen them all, that are being placed by ag retailers looking to make sales this fall, but they're also saying some things that aren't correct about depreciation. So I pose this question to you, Roger.
Yep.
When can depreciation first be claimed?
Well, that's a good question, and it confuses a lot of people. And, of course, what we need to remember is when we read advertisements in farm magazines, that's a retailer that is trying to sell a product. They're not in the business of giving sound tax advice, and sometimes they even say that, but we often tend to read past that. And we like to read into things the way that we think it should apply to us in a good way, and that may not necessarily be the case. And when you come down to the issue of when is the first tax year that I can start claiming depreciation on an asset that I'm going to use in my farming business, the answer is fairly simple to state. It's a little bit harder in its application, but stated, it's when that asset is first available for use, ready and available for use in your trade or business of farming. So ready and available for use. And that's the key. And one of the problems that we see every fall, and apparently it's out there. I haven't had time recently to thumb through farm magazines, but I had several CPAs contact me from across the country last week, and they said, here we go again, Roger, would you please put an article out there of refresher so that I can show my clients as to, these ads that they're seeing by retailers that are saying, if you sign a contract with us by the end of 2022, if it's a building, we'll deliver the materials, we'll drop it in your yard, we'll get it built sometime in early in 2023, or if you just sign a contract with us for some type of ag asset, maybe a combine, a tractor, whatever the case, that's good enough. You can claim depreciation on it this year. And it's a particularly enticing thing for people this year because first-year bonus depreciation drops to 80% starting January 1, and it's 100% right now. So that's going to be a tax increase for a lot of our farmers starting in 2023, and they'd like to jump on that right now. But those ads are misleading in saying you can just sign a contract or we can deliver some product to you and we'll assemble it later, we'll put it together later, and making you think you can claim depreciation on it this year, and you're not going to be able to.
Yeah, and as you have put it, the placed in service, and people may also look at it that way. But I guess, too, with the IRS, and I'm sure, I'm pretty sure that we've seen this particular situation in tax courts. How is this interpreted, or regulations interpreted from the IRS perspective, or if they've gone into court cases from the tax court perspective?
Yeah, we've seen a number of these court cases, not always involving ag, but kind of across the board, also with non-ag products. But property that is placed in service means that it is placed in a state of readiness or availability for use in your trade or business. So if I order building materials, I sign a contract for, say, a pole barn to be put up on my farm, and I even have materials delivered to my barnyard sometime in December, but it's not put together. The concrete foundation is not poured. The sides are not up. I can't use that building this year. That is not ready and available for use. It's not in a state of readiness by the end of this year. And, of course, we get into timing issues with depreciation also. As long as I get something in a state of readiness put in use in my trade or business by December 31, then I'm going to get a portion of a year's worth of depreciation on that, more than just a day. We have different depreciation convention rules that apply. And so it's important to know when I can start, but it has to be in a state of readiness. Just in a pile of lumber in your barnyard's not going to do it. Same thing if I buy a tractor, I buy a combine, I buy a piece of farm machinery. Is that equipment, even though I signed the contract, even though I paid for it, is it ready and available for me to use this year? Now, it doesn't matter whether I actually put it in service or use it this year. It's deemed to be put in service if it is in a state of readiness or is available for use in my trade or business this year. And so that's also a key point to remember. You could buy that tractor, you could buy that combine, it's all serviced, it's ready to go. You signed the contract on it, it's all official, and you just didn't use it by the end of December. You could have, but you didn't. That doesn't matter. You can still start to claim depreciation on it because it was an asset that was in a state of readiness. It was first placed in use in 2022 because it was ready and available for use. It doesn't matter if you actually used it. And so that's also kind of the other side that's important to keep in mind on this.
Yeah, there was a particular case you mentioned, the Stein LLC versus the United States, but this has to do, as a prime example of that, of a taxpayer that was building 2 new retail stores.
Yeah, and as of the end of the tax year, which was 2008 in that case, the buildings were substantially complete. They were partially occupied. The taxpayer already had certificates of completion and occupancy, and the customers could enter the stores. But they were not open for business as of the end of 2008. And what happened in that one, we had a special rule for go-zone depreciation allowance. That was something that was created after I think it was Hurricane Katrina, if I remember correctly. And so it was a special depreciation allowance that was available for 2008, and they claimed that on the 2 buildings, which created then a tax loss on the return for that tax year and allowed the taxpayer, of course, at that point in time, you could carry back a tax loss to, in that instance, 2003, 4, and 5. And they got a refund, and the IRS came in, disallowed the deduction on the basis that they hadn't placed the buildings in service, hit them with a deficiency of over $2.1 million for those tax years. And, of course, the taxpayer sued for a refund on that. And it gets to the court, and the IRS argued that the depreciation, it didn't match, because their revenue from the buildings wouldn't match the depreciation deductions. And that's often what IRS wants to do. They want you to claim depreciation in the year that you have revenue derived from the use of that particular asset. And that's not the key. And the court said that argument is completely without merit. And then on the placed in service issue, the IRS said the buildings were not open for business, so you couldn't claim depreciation. And the court said, no, that's not right either. IRS, you have a regulation that is contrary to that. And placed in service means the asset is in a condition of readiness and availability for its assigned function. And that was a key case on this, and that really applies when we look at these ads that are running in farm magazines. We've got to keep those 2 principles in mind.
In other words, by the way, we only have 2 months left in the year, and there may be several who are listening right now thinking, well, wait, I thought this was this way, but it goes back to, once again, is it ready to go? Can you use it? And especially if you're thinking about purchasing something as a farm asset here in the next 2 months.
That's right. And again, I don't actually have to use it in my business by the end of the year. It just has to be ready and available for use. And that's the key concept to keep in mind. Those are the 2 key principles, let me put it that way, to keep in mind.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. Roger, another case that we're going to talk about comes from the state of Iowa, and this is a case of more in a rural area, but this is a case of an attorney being punished for helping a longtime client and friend.
Yeah, this is, I think, Greg, in all the years that I've done programs with you and Kelly before you, I've never talked about an attorney discipline case. And this is an attorney discipline case that the outcome really bothers me. This is an attorney in a rural part of west central Iowa, and he had a friend. And this is an older attorney. He's in his 70s, and the friend was up in years, but his friend's family had disowned him. And he didn't have anybody around to help him over the years. And his attorney friend would take him out to eat. He had him join his wife and his family at Thanksgiving and Christmas and other gatherings like that. And he really took care of him. And he would take care of his property for him and those types of things. Well, his friend's health started to decline. And so the friend came to the attorney and said, would you draft me a will disposing of my property? Now, he didn't have much. He had a few small lots in this rural community, and he had a lot of junk. He had a lot of old equipment, and you kind of get a picture of this in your head. It's the place where he lived was a mess. He didn't have any help other than his attorney friend, and when he needed money, of course, the attorney would give him some over time, and then when he needed more money, he would buy some of the junk from him, and he would pay him whatever he asked. He never tried to dicker on price with him, and that's how this fellow was able to live. And I'm sure through the friendship of this attorney, he probably extended the guy's life for a number of years. Well, he drafts this will, and his friend said, I want you to leave what I have left after payments of all my debts and property taxes and those type things. Just leave it to your son. And so he did. And after the fellow died, the attorney paid for the funeral. He paid for a memorial for his friend. He paid about $20,000 to clean up the junk off of his properties. And for any of our listeners that have gone through that process, that takes a long time to clean up a property. And he did that for his friend. Well, the family then steps in after the friend dies, after ignoring this guy for many, many years. The family steps in and said, well, the attorney shouldn't have drafted a will that benefited his son, the attorney's son. And they filed a grievance with the Board of Discipline for Iowa attorneys, and they reprimanded the attorney and said, well, you violated two rules. When you bought property from him, you didn't reduce it down to writing. You didn't put it in a contract. You didn't tell him that he should seek other legal advice before you did this. And then you drafted a will that benefited your son. Those are two no-nos, and we're going to give you a public reprimand. Now, that's on the low end of discipline. The high end would be disbarment, which, by the way, the Kansas Supreme Court just disbarred a Harvard-trained attorney about a week ago. But this is on the low end. But I think the guy should have gotten a commendation. I think the guy should have gotten a medal, not a reprimand. We want to encourage this, but the court adopted what I would view as a very formalistic application of the disciplinary rules. And I've told my law students before, you got to watch these rules because a lot of times they're not written in the context of how we operate in a rural setting with our clients. We're often viewed as the family attorney. We do things for clients like this. We become friends with them. And there's a closeness, a bond that we develop in a rural practice with clients that people in a practice in Kansas City or Dallas or even Topeka don't develop with their clients. And sometimes these rules really, when they're strictly applied, kind of produce a rough result. And this one really troubles me.
In so many ways, it's the difference between blatantly going over the rules
right.
or not following the rules versus, hey, this guy is a friend, I'm helping him out. I just
right.
happen to be a lawyer and know some of the things that I could do to help him too.
Yeah, and that's a good point. Plus the amount of property that his son actually received after everything was cleaned up, after all the debts were paid, was a total of under $6,000. I mean, this was not $1 million, $2 million worth of property. This was just his belongings, basically. That's it, and a couple small lots in town. But still, the court said a rule's a rule. You violated two rules, you get a public reprimand. That one really bugs me. I understand what the court is saying, but that's a tough one, and it's one that I'll be talking when I teach the ag law course at the law school in the spring semester starting in January. This is a case that we'll go over with the law students, just to remind them that these rules are out there, and sometimes they don't when they're applied strictly, they just don't work well and produce what we would think would be a good outcome in a rural setting.
Do you see this, or does this type of case happen very often?
All the time. Yep. I may not see a disciplinary action like this. I think it's pretty rotten that what the family did here, and I really question why the grievance commission suggested that he be sanctioned and sent it on to the Iowa Supreme Court. I think the grievance committee should have just deep sixed this and said no. There's no harm, no foul in this one, so to speak. There was kind of a touch foul, but the basketball analogy here, Greg, would be, all right, the guy's going in for a layup, he got fouled, he made the shot, I'm not going to call anything. We see that all the time. If he misses the shot, then you call the foul, but he didn't miss the shot, I'm not going to call it, game on. Just keep playing on.
It's not like he suffered a broken arm or anything.
Exactly.
All right. Hey, Roger, if people want to read what we talked about today, they can find that on your blog?
The first topic is the one about the advertisements in farm magazines and depreciation. The second one I haven't had time to put up on my website yet.
Okay, sounds good. Well, Roger, as always, hey, I appreciate it. I know you're busy this morning, so we'll let you go. But as always, appreciate you joining us this morning.
Thank you, Greg.
That is Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, as he joins us on the Ag Issues program here on 580 WIBW.